Okay, good afternoon, everybody, and thank you for joining us today for our business hour. This is our fourth and final program in our employment law risk management series, avoiding the common mistakes that employers make. This has been a year-long program for us, and today is the culmination, so welcome. Today we're going to be focusing on avoiding mistakes in the termination process. My name's Jim Boutros. I'm the managing member of the Detroit office and a member of our labor group. And with me today, I have the pleasure of being the moderator. And my panelists are Miriam Rosen to my immediate right. She's the chair of our labor and employment practice here at McDonald Hopkins. She's also in our Detroit office. And then our colleague and member and partner, Nicole Gray, who's based here in Cleveland. As I said, this is the fourth program or our final program in our series of four. If you missed any of our other programs and you want to check them out, they're available on our website and or on our business advocate community. And just to remind you, the topics that we covered, back in February, we covered avoiding mistakes that may lead to governmental investigations. In May, we covered the topic of avoiding mistakes in administering FMLA leave, always a favorite. And then in July, we covered avoiding mistakes in handling ADA situations. So again, those programs are all archived. We welcome you to view them if you did miss them so that you have the complete series. For those of you familiar with our programs, and I do recognize a lot of faces, you know that we like to make these programs interactive, and so we do invite questions from the audience, both here in Cleveland and from our webcast audience. If you have a question here in Cleveland, you have note cards at your desk. Please write your question on the note card, raise your hand, and one of our fabulous marketing staff will come and funnel those questions up to us, and we will address them. For those of us in our for those of you in our webcast audience, we have an icon that you can click on. Those and email us questions. Those questions too will be funneled up to us, and we will address them as well. We also received questions beforehand, before the program, and we will incorporate those questions into our program today. We're going to endeavor, of course, to answer all questions that are asked. However, due to time constraints, it may not be possible to get to each and every question. We do want to be respectful of the 1:15 end time. So for those of you here in Cleveland, we will stick around and be happy to discuss any questions that you may have. And for those of you in our webcast audience, we will follow up by email relative to answering your questions. For registering today, we do invite you, you should have received a logon and a password, temporary password, to our business advocate community. That is a blog area where Nicole, Miriam, and myself, along with all of our lawyers here, are blogging about the latest developments in our respective areas of expertise. We invite you to join that discussion. We find it to be a wonderful forum. And so if you haven't already done so, please, after the program today, take the time to do so. Last, we are going to be emailing you a survey of today's program. We really do take those surveys to heart. We welcome your comments, your feedback. In particular, we want to know about topics you would like to hear about in the future. We're going to be sitting down, since this is the last program in our series of four for this year. We're going to be developing a series for next year. We've been kicking around some ideas, but we would welcome your ideas about a series that you would be interested in. So please take the time to fill out the email survey. We really do, as I said, take those comments to heart. So with that, let's get started. How to say you're fired, avoiding mistakes in terminating employees. And there we're off. Okay. Again, this is the fourth in our series, Employment Law Risk Series. Now, the first slide here, just for highlighting purposes, this is from the Wall Street Journal, November of this year, just highlighting the fact that there have been these are three high-profile terminations. And you see various reasons as to why these CEOs were terminated from very recognizable companies. And the point of bringing this up here is how we handle these situations. really will determine whether we go down the road of litigation and confrontation, or whether we're able to conduct a orderly and favorable, if you will, exit process so that everybody is able to move on. And so whether we're talking about individuals such as these CEOs and COs, or what your more rank and file, how we handle those procedures both beforehand and afterwards will really go a long way in determining which route we take.
Well, and even just looking at the language used in each of those termination announcements is really interesting to see what perception that gives to others.
Very true. Some better than others. So the topics we're going to be discussing today relative to the termination process: insufficient, inaccurate investigations and documentations. Miriam is going to be discussing that. Failing to properly handle reductions in force. Nicole will be discussing that topic. Not recognizing when severance is an option, and how to construct a proper severance agreement. I'll be discussing that. And then finally, Nicole will discuss proper exiting procedures. And so with that, let me turn it over to Nicole, or excuse me, to Miriam.
Okay, you need to terminate an employee. How did we get here? I mean, it's my experience, practicing more than 25 years, that employers typically don't wake up one morning and think, oh, I want to terminate this employee, right? It's a series of things that have happened that lead you to that point. It might be poor performance, it might be serious misconduct, there might be economic reasons. But there are almost always legitimate, non-discriminatory business reasons. And since there are those reasons, why do we have so much trouble? You know you have good reason. And that's what we're going to explore today. Some of those reasons, the underlying factors that lead us to be in a position where we have to be concerned about a legitimate non-discriminatory reason. Kind of taking a page from some popular TV shows, CSI, NCIS, we're going to do what I like to think of as a forensic analysis of an employment situation. So let's look at the anatomy of a termination mistake. So you see here some pretty simple facts. We have an employee, age 55, customer service rep at a small company. Newly hired owners new owners of the company were younger, might not have a lot of employment law experience. They're not too happy with her, but they've heard rumors maybe that she's going to leave, so why bother taking the time to discipline or document? But as it turns out, and I think many of you will probably identify with this, she doesn't retire. She comes in and says she needs a medical leave. That sound like a familiar situation? See a few nods of the head. Well, they decide, we don't want to give her a leave. We can't possibly afford to have her gone. Wait a second, she's not that great an employee, but you can't possibly afford to have her gone? So they decide they want to terminate her. Luckily, they decide maybe they'll check with their HR person and see if this is a good idea. And it must be a good idea, right? Because she's an at-will employee. So that leads us to our first termination mistake, the at-will employment mistake. Now I'm guessing many of you have heard this from executives that you might report to who want to make decisions. But this is an at-will state. This is an at-will employee. Why can't I terminate them? Why do I need documentation? Well, it's really because most people don't think of the whole statement. At-will employment means any reason or no reason, but not an illegal reason. Some of you might like to have that as a plaque on your wall, right? And we've got some of the illegal reasons up there, and I'm sure many of you know them. Protected categories, but frankly, more recently, some categories that even go beyond that. Retaliation, whistleblower claims. We're seeing a huge increase in those types of complaints. Employee makes a complaint about, in the healthcare industry, let's say, billing practices. Shortly after, there's a termination. That leads the employee to believe that the termination was for an illegal reason. I complained about fraud. So, since we know that even if you have an at-will employee, you need to fire for a legitimate non-discriminatory reason. How do we establish that?
You know, just before we go on, and Miriam's going to be discussing about building that documentation, but I think that I can speak for all of us that the one very frustrating factual scenario we'll get is when an employer comes to us after they've already made the decision to terminate, they've effectuated the termination, and we read the termination letter that says, "Dear Molly," in this instance, we're exercising our right as an at-will employer, and effective immediately, your employment's being terminated. The frustrating thing about that, of course, is number one, it's not as if, I mean, what does at-will really protect us from? At-will protects us from a contractual claim. I mean, that's really its genesis. That is, we're not promising an employee an employment for any specific duration of time, as opposed to an employment contract that has a 5-year duration, 3-year duration, etc. So we don't have a contractual claim. But as Miriam is pointing out, we still can't fire for illegal reasons. So it's important for us up front, and hopefully the documentation that brings us to the termination date will support this, but that we state the reason for termination. That's very, very important. It's not because they're at will. It's not like we got up in the morning, had an itch, and decided, you know, today's the day as an employer I'm going to exercise my at-will option, and I'm going to fire Molly, or I'm going to fire Joe. There's a reason, whether it's performance, whether it's attendance, whether it's some interpersonal conflict. And so we want to be certain that we're stating that reason up front.
An issue comes up a lot when you're having a meeting, when Nicole will talk about, do you say the reason, don't you say the reason? Mm-hmm. And you know, you can pretty much tell our position is you need to communicate a reason that shows that it's a legitimate non-discriminatory decision. So, you know, in our situation, do we have any documentation? We don't have any documentation. Is that a problem? Is lack of documentation a problem? It is. Why? Well, having documentation supports your legitimate non-discriminatory reason. Shows that you were following your policies, shows that you were following established practices, and again, creates legitimate non-discriminatory reason. But is lack of documentation fatal? Not necessarily, if you've done things right all along. So let's start out by documentation begins with the very first, the establishment of that employment relationship. So you're probably thinking, why am I going to talk about hire? Because you're establishing some important things right from the beginning of that relationship that really affect the end of the relationship. So you need a good employment application that makes clear that the relationship is at will, but also does a lot of other things. Establishes, first of all, you have to be truthful. So maybe you're terminating an employee because they lied. Well, where's good documentation that you signed in the employment application that you would be truthful? But if you don't have an employment application, you're missing something that was easy to get at the beginning. Job description, that might help show. In this case, it could have maybe helped show that Molly wasn't doing her job because she was supposed to respond to a certain number of complaints or customer concerns or do other things. So right up front, you need good documentation. And then, of course, throughout, if you have disciplinary problems, Molly here, what the client communicated, and this is a real scenario, I didn't make it up, was, yeah, there are lots of customers who are complaining about Molly. Okay, where's the documentation of that? So the documentation all along will help you establish that your termination is for legitimate, non-discriminatory business reasons. So what else establishes your legitimate, non-discriminatory business reasons? Well, we all know this, performance reviews. Performance reviews are hard, and they're hard to do accurately and honestly and timely. But if you have them, they will absolutely help you show that there is a problem that you were addressing at the time of termination. So, and you know that, everybody knows that. But since it's hard to do, I think the better question is, what can we do to help ensure that we give good, timely feedback? So a couple things I think we've kind of gleaned over the years. Once a year, not enough. But it's still hard, even if you're doing it a little more frequently. So set some expectations up front. Let your employees know that you're going to be giving them feedback from time to time, so they have an expectation that they'll hear things that they might not like from time to time, so it doesn't create an unpleasant situation. And then once you've communicated about those performance issues, make sure you document them. I would say we might all agree that the biggest problem with performance evaluations is that people are too nice. You've got a supervisor who complains and complains and complains, and then you get the evaluation, and it's all good. Well, wait a second. How do you act on that? So you have to teach managers to accurately communicate difficult things. And you need to teach them to communicate those difficult things in the right way. Because sometimes we find that managers are documenting, but the documentation hurts us more than helps us. Documenting isn't natural. And you know, if a manager is frustrated about an employee who's absent a lot, they're likely to write something like, Sandy's out too often because she's sick. Or, you know, she couldn't be here on Sunday when we were putting the new system in because she had to go to church. Well, what is that documentation of? That's documentation of a reason you're not supposed to be considering. So as you're going through and teaching your managers how to document, you need to make sure they understand what's appropriate to document. The business reason they're trying to get at. Sandy isn't getting her work done. Let's not speculate about the reason. She's just not getting her work done. Another thing that we see frequently that's becoming a very big problem is documentation through email, text messages. Supervisors don't always think that email, which seems like a conversation, is going to end up as an exhibit in litigation. And I can tell you that it does. And even text messages now are coming back to haunt employers. So you need to drum into your supervisors that written communication can come back to haunt them.
Just before we leave performance evaluations and to highlight some points that Miriam made there, it's more detrimental, frankly, to have a inaccurate performance evaluation than to not do one at all. To go to the point of what Miriam was saying, that this employee on paper, it looks like Jesus Christ, okay, when they're actually, they're a very poor performer, okay? Because we can't, we struggle as human beings to be critical of one another. That's a natural tendency. We want to fill in the all fives box or all fours on a scale of 1 to 5. But if we're not accurate, and then the call comes in and we'll be told we're ready to terminate Molly, she's having all of these performance issues, and then we look at the performance evaluation, it's just not reflective of what's going on. And that type of document is frankly, the fact that you did that is going to hurt us more than if you had not done it at all. And then just going to your point, Miriam, and get your thought on this. I know some of the pushback that we get, there's the perfect legal world where we want everything documented. And then there's the business world, right? You guys are busy running a business. I don't have time to be tailing Molly, making sure that I'm documenting every little issue with her. So when we run into those situations during the busyness of our day, even though we might not have time to fill out a formal disciplinary sheet or performance improvement sheet, what are your thoughts relative to shooting an email to just cover the file, so to speak, even though we have to be careful to be not casual, if you will?
Yeah, I absolutely think, absolutely. You have to balance the practicalities of business with the need to have some documentation. And one way to do it is certainly to send yourself an email, communicate to yourself, make a note that this happened, and especially because you know, it might happen 5 times, and you remember it happened, but you don't remember when it happened. So send yourself an email, create some documentation that will remind you, so when you do end up sitting down, you can say, you know, this happened on these occasions, we talked about it. Or even, if you, maybe you sit down with the employee. So let's take Molly's situation. There was a customer complaint. Could have easily had a quick conversation about the customer complaint, and then a short email that documents, we spoke about this on this date, you agreed to do this. 3 lines. It doesn't have to be hard. And I think sometimes we make it harder than it has to be because we feel like it's got to be a formal session, you have to document it in a certain way, the issue, the concern, and how it's going to be corrected. And that gets to your documentation.
And just before you move on, one more thing about documentation. I think we need to address the handbook that falls in here, because a lot of times your terminations may be driven by a violation of your handbook or your policies or procedures, your standards of conduct that are included in that employee handbook. And from a bad documentation standpoint, we'll see termination notices that say you're terminated for violation of company policy. Well, what policy? What was done? What amounted? What constituted that violation? So giving your managers training on, your supervisors on training on having documentation that gives you a full picture, as well as making sure that your managers know what's in the handbook. Because I've seen a number of times where managers have assumed that a policy or a standard of conduct was in the handbook and terminated someone or disciplined on it, and then we actually looked at the handbook and that wasn't in there. So making sure that we understand that the handbook is a living document, we have to use it as a resource.
Which kind of goes to, again, training supervisors. It's worth it to have a session to include in maybe a regular management meeting some updates on the handbook so they know what's in there, especially if you're seeing problems on certain issues. You don't have to spend a day training them on the handbook, but just quick updates.
We did get one question on just differentiate between just cause termination, or when we're in a just cause situation versus the at-will situation.
So we talk about at-will employment. That's a contract that you can establish. In the public employment setting, most employment is just cause, which means you have to have a reason. You have to follow procedures. So of course, you want to make sure that you're following those procedures, you're aware of the standard, and that would go back to either a collective bargaining agreement or policies that are in place that create those just causes. And there are some private employers that do create a just cause standard, either because they've made contractual promises, either with certain employees or with all their employees sometimes. And if that's the case, and you've created a just cause standard, then you need to make sure that you're following your policies, and you only fire when you have reasons that fit those just causes. It's a more difficult standard, but some people may say, well, it helps guide me and it shows that I did have a legitimate non-discriminatory reason. It's important to make sure you understand what just cause is, though, before you terminate. So let's get back to our friend Molly for a second. So one of the things that the employer did have in this case was they said, well, she was making all kinds of mistakes. She would yell at customers when they called in. She was short with her coworkers. Okay, that's something. Let's talk about that. Did you talk to any of those customers? Did you follow up? Did you talk to the coworkers about what happened? No. Okay. So the way that we establish that our reasons are legitimate is we look into the reasons behind the termination. So to investigate or not investigate. If you have complaints, either through coworkers or from outside, you want to make sure that you've taken the time to look into them so you can document the fact that this happened and this was a performance problem. What we see lots of times happening is employers either take the word of the customer or they take the word of a coworker. As I was preparing this, I thought of a good story that illustrates the need to investigate. A number of years ago, one of my clients had a package delivered for an employee in their mailroom. The package fell on the ground. It opened up. It was a Bible, but it was carved out, and pills fell out of it. And it turned out that they were various types of illegal pills. They called me, well, we need to terminate right away. We have a no tolerance policy. And clearly this employee was having pills delivered to them. Well, it does sound pretty bad, and I couldn't imagine how the employee would avoid being terminated. I said, well, let's talk to the employee first and see what's going on. What's the explanation? So they were ready to terminate because this clearly violated their drug policy. But they conceded and they called the employee in and they talked to the employee. Turns out the employee had no idea what this was about. After kind of a protracted situation, the employee's mother-in-law had sent the Bible to him at his place of work because she wanted her daughter to have these pain pills because she thought that she was in pain from a recent medical treatment. I know it sounds crazy, and we never would have got to that point, but it was absolutely true, and it saved the employee his job. So sometimes doing that investigation is well worth it, because you probably all know with employment law, you can't make this stuff up. Plus we know, as you see here from the comments, that if you do get into a litigation situation, juries expect that you will have investigated, and not just juries, but if you've got an EOC charge of discrimination or some other agency, they're going to say, what did you do to look into the situation? If you say, well, we didn't do anything, that's a problem for you, not the employee. So, timing. Timing is a big issue in terminations. So, what was the problem here with the Molly situation? Well, Molly needed a leave of absence, or Molly asked for a leave of absence, and that's when the employer decided to terminate her, just after. If they had a week earlier said, Molly, you're not performing and we're going to terminate you, that would have been one thing. But when the discipline decision, termination decision comes shortly after employee has engaged in some protected activity, asked for a leave of absence, announced a pregnancy, it's suspicious timing. And it looks like maybe there is an illegal reason. So a couple things. First of all, documenting issues beforehand helps to establish that it wasn't related to the protected activity. I've had clients who make a decision to terminate but decide for logistical reasons they can't implement it. But document the fact that you've made that decision, because sure enough, what happens? You make the decision and the employee tells you they need a medical leave. They tell you they're pregnant. And then it looks like you made the decision based on that protected activity. So, as is often the case, I happened to find a new case that was just published that goes to the timing issue. So, a manufacturing company in Pennsylvania had an employee who was bipolar. And apparently it had a series of kind of violent outbursts at the factory over the years. Employee goes on a 2-week FMLA leave, comes back, tells the employer that he's going to need some additional time off to address not just the bipolar issue, but a number of other issues, and then has a similar, not necessarily violent, but unfortunate outburst, and the employer decides to terminate him. So what happens? ADA lawsuit. And here's what the court had to say. The discharge occurred several days after he returned from medical leave, where he told them he needed more time. But here's what the court said. The employer had tolerated his poor behavior for years. He had good ratings. And in fact, in his recent review, just 2 months earlier, the employer said he gets along with everybody, which was the reason they decided to terminate him. So did the court dismiss the case? Absolutely not. The court said exactly what we're talking about. Based on the timing, it's possible that this case, that he could have been dismissed based on his condition. So we see how timing really is everything. If the employer had been accurately documenting these situations all along, which I'm sure were frustrating to them, maybe they would have been in a different position.
Just to kind of bookend that, when you're ready to make the decision, and I think we would all agree, because Miriam was talking about a client that she had that wanted to make sure, in essence, everything was organized and they weren't ready to execute the decision even though they'd made the decision. I had a situation one time where on a Friday, the employer was ready to terminate, and the documentation supported the termination decision, but wanted to take the weekend to make sure that the file was in order, to make sure that they had conferred with the CEO who was out at the time. And lo and behold, on that Friday afternoon, the employee at issue came in and asked for an FMLA leave. Well, now we are the victim of timing. And the point of that story, and it's not a story, it actually occurred, is that oftentimes employees know when they're on the proverbial chopping block. And so if you don't move when it's time to move, I'm not telling you to be imprudent, I'm not telling you to be hasty, but when you have the documentation in place and it's time to execute the decision, execute it so that you don't become the victim of a bad timing situation like that, because we do find that in these situations, more often than not, employees know when that decision is going to be coming down, because if we are a good employer, as Miriam is stating, this shouldn't be a surprise that we're going to make this employment decision because we've been documenting all along. So when it's time to move, move and execute the decision.
So our last criteria, let's say, for analyzing an anatomy of a termination is the inconsistency mistake. Can't possibly let Molly go on a leave of absence, but we've approved another leave of absence for a younger employee. What does that add to Molly's case? Well, certainly this was because of my age and my medical condition, when you've treated someone else who appears to be similarly situated differently. And it's not just the case with approving a benefit, maybe like a leave of absence, but how you enforce your policies, how you issue discipline. You know, there are absolutely reasons for treating different situations differently, but overall, someone is going to ask you, if you've terminated an employee, they're going to ask you, how did you treat other employees in the same situation? And if you've treated them differently without a good reason, people are going to come to the conclusion, people meeting courts or the EEOC or some other government agency, that you've made that decision for an illegal reason instead of a legitimate reason. So here we go back to documentation. If there's a reason to let Holly go on a leave, but you couldn't let Molly go, you need to establish that legitimate non-discriminatory reason in documentation. The most important thing that most HR professionals know is be consistent and document your reasons. And we're going to go to Nicole, who's going to talk about terminations on a little larger scale.
Right, so there is some carryover from what we've been talking about as far as documentation and consistency, but there's additional risk when you have a situation where you're terminating a number of employees, and typically we refer to them as reductions in force. And there may be many reasons for a company to go through a reduction in force. There could be internal factors. You may be having a company reorganization, maybe eliminating a business division or a business line. It could be external forces, economics. It could be loss of a customer, change in supplier. But the business objectives of a reduction force tend to be the same. They tend to be, you want to reduce costs, you want to retain your best talent, and you want to prepare for the uncertainties of the marketplace ahead, right? You want to be nimble, you want to be flexible and streamline your operations. If you're not careful, however, the consequences of your reduction in force could be costly and result in litigation. And now you have a class of individuals that you may be looking at because it's more than one who's being terminated. So how do reduction in force problems typically develop? Well, there's a couple of things that we've put up here that are, I would say, the general mistakes that we see. Failing to follow your policies. It goes back to, what does your handbook say? Do you have a policy in your handbook about layoffs? Does it say in there that you're going to do it based in seniority? I've seen a lot of handbooks that say that, and you know what? It's not used. That's not how people are doing it. So be cognizant of what your documents or what your policies that you have in place say. Failing to analyze whether there's going to be an adverse impact from your reduction in force. So is the termination going to have an effect of having an adverse impact on a protected class? And so that requires to look at your demographics of your workforce currently. What are they now? And then if we implement this reduction in force, what are the demographics then? And you may see things that are inadvertent. And all of a sudden you have a list of 25 people who are being terminated, one of which is under 40. And it's inadvertent, but now on its face, it could be age discrimination. Would be. Would look.
Yeah, I mean, sometimes, you know, the demographics turn out that most of your employees are over 40, and so you can justify the decision, but, you know, you have to look at that and find the, again, I'll go back to my catchphrase of the day, the legitimate non-discriminatory business reason that supports that. But certainly, you know, when you see those kind of things, you want to investigate.
And at least have the data so that you can analyze it and understand what your risk is. And then using improper, inconsistent decision criteria. So really here, and we'll talk about this a little more in depth in the next slide, but using different standards to make decisions, right? If you've identified your decisional unit, who are the people that we are looking at to make these cuts, well, how are we making those decisions? And then we've called it playing the shell game. I call it playing favorites, trying to strategically move people into positions to protect them from termination, or moving the problem employee into a area where there's going to be a rift taking place so that you can get rid of that problem employee. So again, being cognizant of the workforce and the movements that you're making. The best way to guard against these problems that typically develop is to plan and prepare for your reduction in force and manage the risk during your selection process. And we'll talk about as well, you know, obtain releases. You know, minimal severance may do the trick in these types of circumstances where you can obtain a release. Also, consider involving counsel early. And again, I always give a shameless plug, but you know, one of the reasons is that you may be able to protect a lot of your conversations about reduction in force through attorney-client privilege. If you're having these discussions about adverse impact and your demographics of your workforce and how to plan and prepare for a reduction in force, if you're having those discussions with your attorney, you can cloak a lot of that in attorney-client privilege. So we're properly planning for our reduction in force. And first, we want to clearly articulate the goal, right? What are we doing with this termination, this group termination? What's the end goal? Do we want to reduce the number of employees, overall headcount? Do we want to have a percentage reduction in operating costs? Do we want to eliminate an unprofitable business line? What's the end goal? And then, how are we going to get there, right? What's the criteria that we're going to use to reach that goal? And between those two objectives, we need to then establish the business case for the reduction in force, right? And the business case rationale for your reduction in force, it's going to prove invaluable for defending against some type of class action or collective action that may come later. So when we're talking about designing the selection process, you know, you want to identify, first of all, I called it decisional unit, but who are the people who are going to be affected by this reduction in force? What are we looking at? A specific division? Are we looking at a specific location? You know, who makes up the pool of individuals that we're looking at? And then once we have that defined, how are we deciding who stays and who goes, right? What criteria are we using? And a lot of times we divide it between objective versus subjective, but I like to use competitive versus non-competitive. So you know, you have non-competitive selections that are made without regard to individual qualities. They're based on business needs, right? They're a decision to outsource a particular function. We're no longer going to do billing in-house. We're going to use an outside company. So billers, we don't need you, right? That's a non-competitive. It's not about that you're good at your job, Joe, as a biller, and Sally, you're not. It's we're not going to do this here anymore. So that's a type of non-competitive selection. However, a lot of times our reductions in force involve both non-competitive as well as a competitive selection, where you're dealing with things like performance ranking, you know, sales numbers, skills, job seniority. So if you have that type of situation, to the extent that we can use objective factors to establish those competitive criteria or the competitive selections, then the better off we are in defending those. So when we're looking at objective criteria, what are we looking at? We're going to establish things like sales numbers, right? We can use that to show who's productive, who's not productive. Do we want to use performance evaluations? Well, do we have performance evaluations? What do the performance evaluations say? All right? So these are the things we want to look at. And from dealing, in HR and dealing with managers on a regular basis, if your managers are consistently filling out performance reviews and how they're filling them out. So we also want to make sure that we're being consistent across the board, right? We don't want one manager to use seniority and another manager to be using performance to make these decisions. We want to have consistency so we can establish the legitimate business reason for the reduction in force. And once we've had that selection process, really the business case falls in line, right? We have the goal for the RIF or for the reduction in force. We have the selection. We have the decisional unit, who's going to be impacted. We have our selection criteria. And so being able to establish that and showing that you took these steps to plan this out in advance really helps to cut against a plaintiff's argument that somehow you base this reduction in force on illegal, unlawful characteristics such as age, such as disability, such as gender. So we do want to recognize that a reduction in force situation, it's different. And it can be as few as 2 people could constitute a reduction in force. So we want to recognize that it's a different type of situation, and it has additional legal issues that come with it. So we've talked about the adverse impact consequence, where you have your reduction in force, your decision-making criteria has taken an effect on a certain protected class, whether hopefully it's inadvertently. So those are things to be mindful of, and again, why we want to analyze the demographics. And if that happens, if we're looking at this and we're preparing and we have this data, well then it's time for us to evaluate other alternatives so that we can look and say, we looked at the risk as a whole and we understood what that consequence was. And this is why these alternatives wouldn't have worked, rather than not evaluating that. And then we also need to address, is this a situation where there are other laws that we have to take into account? Are there Warren implications? Meaning, do we have a large enough termination so that we have to give 60 days notice to these individuals?
No, Nicole,
are there state laws?
I'm going to interrupt you right there because we actually got a question just on the general parameters of Warren, a covered employer. Could you just elaborate on the basics of when we're in a Warren situation?
Well, and Warren, I would love to say Warren is basic.
Let's give the nuts and bolts in terms of a covered employer and when we're in that situation in terms of a layoff or a closing.
Yeah, so in general, we would be looking at an employer that has 100 employees and where you're having a reduction in force be affecting more than 50 or more employees, is where there's a requirement that you're going to give 60 days notice to these individuals. And if not, then you could be liable for the wages and benefits that they would have been entitled to during that time period. And there's distinctions between if there's a mass layoff or if there's a plant closing. But it's something to be cognizant of if you're getting to that 50 threshold. There's also a lookback period. So if you're trying to be clever and terminate 25 one week and then 25 the next week and then, right, there's also a 90-day lookback period. So, you have to be mindful of the decisions that you're making as a whole.
What I would say about Warren is it seems like it's straightforward, but it's very complicated. Mm-hmm. We probably counted people and numbers, and so again, another opportunity to consult your attorneys about whether it applies or not. As it turns out, I would say we probably find that in many situations it doesn't apply because the numbers don't add up. Whether you've terminated enough relates to where the employees sit, single sites of employment, and total numbers. It's a complicated statute. So ask for help because you might not want to be on the hook for 60 days if you don't have to be. Or you want to make sure that notice goes out if you need it. Right.
And just to that end, I mean, we will, and to highlight that, we will confer amongst each other when we have these warrant situations in terms of batting around whether it's applicable or not, and seeing if the numbers can be, or are they, the layoffs staggered and such, or can we manipulate it that it's not applicable. So to highlight the point, this is something that whenever we get that question, we're always refreshing ourselves and consulting with each other relative to making sure we get it right. So it's not something to take lightly and just assume it applies or assume it doesn't apply.
Well, and then last on this reduction in force situation, it is really prime for an opportunity to do a severance and release option for an employer. It ties up the employment relationship with a number of employees and gives you a release. But there are different provisions that apply to a reduction in force situation rather than an individual termination. And so we have to be mindful of what those requirements are under the Older Workers Benefit Protection Act. So employers have to give employees 45 days from the receipt of the disclosure to sign it. After they sign it, an employee has 7 days to revoke it. And then also there's an additional requirement, we like to refer to it as the Exhibit A, that goes with the severance agreement that lists the decisional unit. Who did you look at for this reduction in force, and who was impacted, who stayed, and who goes? And you have to list their ages. You don't list their names. Usually we list divisions and job titles, but you list their ages. And depending on the size of your workforce, it's pretty obvious who it is. And it can also become, I mean, it's a document that you want to be mindful about, because it can also become Exhibit A in a plaintiff's case as to, on its face, discriminatory for age purposes. So it's something, to get assistance with.
Yeah, let me just add, I see frequently the mistake of having that 45 days in severance agreements when it doesn't apply. So you got a severance agreement from us when you were doing a reduction in force, and you think, I have a severance agreement, I'm just going to use it for a single termination. You don't have to give 45 days. It's great if you want to, but for a single termination with an employee over 40, it's 21 days, and Jim's going to talk about that. But you want to make sure you don't have to give a list of who was considered when you're doing a single termination. You want to make sure that you're using the right documents for the right situation.
And then I would just wrap up with the reduction in force section with, don't call a termination something it's not. If it's not a reduction in force, if it's not an elimination of a position, if it's a termination because of performance or a violation of a company policy, say that. Don't get into a situation where you're now explaining why you wrote a letter saying we've eliminated your position, yet I hired a 25-year-old to replace you. Don't put yourself in that position.
All right. Before moving to severance, I was going to address a couple of questions that we've gotten. One question here was, how often should the handbook be updated? Yearly, couple of years? I think as a good rule of thumb, yearly is a good rule of thumb, and it's nice if it coincides with your business. So if you're on a calendar year, a fiscal year, that's a good time to conduct a review. Laws are changing on that, with that type of frequency, or there are nuances that it at least makes sense for you to sit down, look at your handbook, look at it with counsel, and make sure that it's up to snuff, and where it needs to be amended, because as we've all been preaching here, it is a living document that's meant to be updated and amended, then do so. Another question we got is relative to documentation. This goes back to Miriam's section on documentation. And when we met out discipline and we're documenting it, is it required that the employee acknowledge receipt of that documentation?
So it's nice if you can get the employee to sign it, certainly. If we have levels of what we'd like, that would be great. But if you can't, you can certainly acknowledge that yourself, provided to employee, refused to sign. If you have a witness there, you could have the witness acknowledge that as well. Look, you're not going to not do your documentation because your employee won't sign it. You're the employer. You get to issue the discipline or the documentation. Do it. I see another question there is, well, what if I'm just emailing myself? How do I have proof? Well, you know, it's part of a process. You're gathering your notes and your thoughts so that you can communicate with the employee, and you have a record. And even though the employee might not have signed it, you have a record that you created contemporaneously that you can then use. It's something. It's better than nothing, and that's kind of what we're looking at. Can you start to establish that you have documentation that something happened?
I think that's exactly the point. It's better than nothing. Because an employment case is much, excuse me if that's me there, much like I analogize it to a medical malpractice case. And that is, if it's not in the chart, it didn't happen, okay? Because the one thing you can count on your ex-employee, the plaintiff in an employment suit, saying is whatever you say is the reason, whatever you say has occurred, to the extent it's not corroborated by contemporaneous documentation, they're going to say the opposite. I know it shocks you that they're not going to agree that they were a poor performer or that they had attendance issues, but trust me, we've actually seen that happen, like on every occasion. So again, if it's not in the file, we get a he said, she said situation, and all that really does, it makes it very difficult for us as your employment counsel to get that case dismissed by the judge, because that's a credibility contest. Do I believe the employee, either the ex-employee, or do I believe the employer? And that buys me a jury. And when I get to a jury, we don't know who's going to be sitting in that box. It could be 6 business owners, and then I like our chances. It also could be 6 ex-employees that feel that they got railroaded by their employer. Then I don't like our chances as much. And we won't know that until the day of trial. So let's take control of our employment environment and document as best as we can. And this question about the emailing, I think, really goes to the heart of it. Is it perfect that we're just emailing ourselves and we're not getting acknowledgement? No, okay? But remember how we said there's the perfect legal world where we'd like everything on our nice disciplinary form or progressive disciplinary form signed by the employee versus not doing anything at all because we're too busy running our business. We meet in the middle, okay? That's where this lives. And we're going to be successful more times than not if we're meeting in the middle. And I think this emailing concept, or just jotting a note that you had this conversation, sticking it in the file, is better than nothing. And then one of the last questions we got here before moving on was, what circumstances would justify immediate termination? And I mean, oftentimes that's dictated by our handbook. We'll actually delineate what circumstances will dictate immediate termination, such as theft or violence, etc. Really that's what that drives us. And then there just are those circumstances, even without that I wouldn't feel uncomfortable if it was that egregious of a misconduct or violation that we could move right to termination. Again, the key though is we'd have to be consistent. So if we had a situation with somebody using alcohol on the premises before, and we gave Joe a final written warning, and Joe was Caucasian, and then Mary comes along and she's African American, and we terminate her, well, now we've created we've created that situation where we're not treating apples and oranges the same. We have to be consistent. And then last is there was a RIF question. And the RIF question, employers considering a RIF and yet is also considering adding different skills or new positions. What's the risk in that situation?
Well, I think it depends on, again, going back to planning and identifying where's this RIF taking place, right? Is it a line of the business that you no longer need? Is it individuals who don't have skill sets? Is that a performance issue? Or is it really a change in your business and your line of business rather than, I would be careful not to mask or call a RIF something that's really just performance-based. If really what you want is new skill sets, then maybe an alternative is, are we training our existing employees? And if we can't train them, why not?
Yeah, I would say, I mean, these two ideas aren't inconsistent.
Right.
You know, an old skills going away need different skills. We have that a lot. Or we need to upgrade skills. But you know, it all goes back to the business planning. Can you support that the current employees who are going to be eliminated don't have those skills, and the new employees have different skills? It's you know, just about business planning, which is part of what we do all the time.
And I guess one final question here I'll touch on, and then we'll move on. Progressive discipline. We got a question about a progressive discipline policy in an at-will environment. Well, that's not uncommon still to see a progressive discipline policy in an at-will environment, but in that policy we are reserving the right to terminate immediately if we feel that the circumstances dictated as such. So we can have it as a guideline relative to having a 3-step, 4-step progressive discipline policy, but as an at-will employer, we reserve the right under the circumstances that in our discretion we deem appropriate that we can immediately terminate. So that's how those two concepts can coexist.
Inconsistency.
And
right?
consistency.
I mean, if you're
always.
using a progressive discipline
Yep.
policy for one and you're not using it for somebody else, that's
For a like
problem.
kind offense, absolutely. You have to be consistent. And that is a hallmark throughout this presentation, is consistency.
Yeah, I would say most employers, I can't think of very many employers that don't have a progressive discipline policy. You know, there's, it's being a good employer, helping employees do their job. So absolutely consistent.
And at the end of the day, you've made an investment in your employees, and so you know, to have a progressive disciplinary policy isn't you know, at odds with that.
Turnover is costly. So if there are those types of infractions that are quote-unquote minor infractions and that employee otherwise has a valuable skill set and can be rehabilitated relative to the issue at hand, then it behooves us to do that as a business proposition. So let's move to severance if we can. And severance is an opportunity in the termination context for us to insulate ourselves from liability in inappropriate circumstances or where we deem it appropriate. And generally speaking, and I'm sure all of you are familiar with it, it is the offer of consideration that is not otherwise due to the employee in exchange for a release of claims. And also we can get some other perks and benefits out of it. In a standard severance agreement, although the EOC, as we're going to touch on here, has been challenging some of these provisions, but we can get a confidentiality provision. Confidentiality as to the information to which the employee was exposed during business, during their tenure with us, and also confidentiality as to the terms and conditions of the severance agreement itself. A non-disparagement clause. Again, being mindful of, I'll touch on some new EOC concerns in this regard. Also, for those of you that are familiar with the NLRB's position on non-disparagement clauses, in particular in the social media, we got to be mindful of the fact that we can't completely squelch an employee's right to talk about their terms and conditions of employment. Critically, we can provide for the return of property, okay? Return of company information. This is critical in terms of making sure that our employees are not leaving with confidential and proprietary documents and may be going to our competitor and will use that information against us. Again, if we're in a situation where we're severing an employee, that's normally not a situation that's entirely everyone feels good about. So if you have someone that's disgruntled and they have the opportunity to use your information against you, that is a situation that they may very well do so. It also can help provide in transition issues. That is, some agreement that for a period of time, for example, that they will be available to help in the transition of their duties and responsibilities to the replacement, and or be available to answer, for example, customer questions, etc. Sometimes there can be an economic component to that. I'll pay you X dollars per hour for the next year that you're available to consult with me, something like that. But we do have the opportunity to make that transition smoothly to that individual's successor and or the business issues that may come up that employee was dealing with. And then post-termination obligations and issues. This is an opportunity for us. I mean, I have a note to myself here, since I do a lot of this type of work, is we can consider whether we want a restrictive covenant as part of a severance agreement in terms of non-solicitation of company customers, non-solicitation of company employees. If it's a high enough ranking employee, an actual non-compete in a particular line of business for the duration, for example, of the severance agreement, if it's being paid out over time, or for a defined period of time, if we're concerned about that individual's ability to compete against us and compete against us unfairly.
Or if we already have one and we want to make
Well-
sure that they remember their obligations under it and put
And
that
we're-
in their agreement.
And absolutely, and that gets a little bit ahead of us, but the one thing that I'm always concerned about in severance agreements, normally we'll have those nice merger clauses that says this agreement supersedes all prior oral discussions and agreements covering the subjects contained herein. I've had the situation come up where a employer put a non-compete provision in a severance agreement that was not as robust, if you will, as the non-compete or non-solicit that the employee had originally executed upon hire or upon receiving some sort of remuneration for it during the course of their employment. And all of a sudden, now I'm stuck with the lesser restrictive covenant when I might want to take advantage of the more robust one. So it's important for us, before we offer a severance agreement, to make sure that we're analyzing the personnel file, to understand what the employee has signed to date, what employment agreements are in place, restrictive covenants, confidentiality agreements, to make sure that I am not, in essence, eviscerating otherwise valid agreements that I want to use post-employment. So why would I offer severance? What are some of the reasons? Well, if I don't have I'm not satisfied with the documentation in support of my termination decision, that would be one. If the employee is in a protected category, or if they're in a situation relative to retaliation, they coming off a recent leave, whether it's an FMLA leave, whether it's an ADA leave, that might be a situation that would call for the offering of severance. Does the actual employment contract itself of an employee and or our policies and procedures call for severance in a, let's say, termination without cause situation? So making sure that I'm acting consistently and offering severance with an employment contract or policy that exists that calls for so much severance for this many years of service, 2 weeks for every year, something along those lines. So making sure that I'm not forgetting what the employee may have executed that already calls for severance. And then what's the nature of the misconduct? Is this something that's truly egregious? Is it something that was a progressive situation, maybe attendance, something that's more minor, where I am willing, if you will, to offer severance in that situation? Now, it's important to remember that severance agreements are a legal document. What do you need to have in a severance agreement? The basics for it to be enforceable. You got to have consideration, and it's got to be something that the employee was not already entitled to, okay? And that is, we'll often get the question, hey, can I offer a bonus or the bonus payment if the employee signs off on this release and use that as a consideration? And the answer to that question is, if they were already entitled to it under the terms and conditions of their employment, then it cannot serve as consideration for release. It's got to be something above and beyond what they were already entitled to in order to constitute valid consideration for the release. You want to make sure that the employee is releasing all claims. So we have a very robust release claim. Covers all federal laws, state laws, local laws, contractual claims, promissory estoppel claims. You can imagine that paragraph definitely contains the full laundry list of potential claims against the employer. And then we've already touched upon timing issues here, that when we're in the ADA context, okay, an age discrimination context, we have to afford the 21-day, when we're in a single termination situation, a single employee termination, the 21-day consideration period and the 7-day revocation period. And we also have to advise the employee that they have the right to have the agreement. It's their right to exercise, whether they choose to or not, at their own expense, to have it reviewed by counsel of their choice. We have to advise them of that. If we don't provide those provisions in a situation where someone is otherwise covered by the ADEA, normally, and some state laws vary, but under the ADEA, it's somebody that's over 40 years of age, then our release is effective as to everything but an age claim. So we could end up in a situation where we've offered and paid the consideration, they've released everything, but they're still capable of bringing an age discrimination case against us. So we have to be mindful of that.
Let me jump in. I know we're running along a little bit, but let me just jump in and say, I can't tell you how frequently I look at severance agreements that are misused. You got it somewhere, and you just keep recycling and recycling. It hasn't been updated. It's been distorted for different situations. Really, if you have a basic document you're working off of, I'm going to do another shameless plug. We don't want to recreate the wheel, but we want you to have a legally effective document that protects you. And so even a quick review to ensure that your document works for you is really important.
And Miriam is speaking to this very slide here. That is, we don't want you to, hey, you used a severance agreement 2 years ago, okay, when you terminated Molly, and now you're in a situation where you have to do it again. It is important to make sure that your agreement is up to date. As we're going to touch upon here in another slide, the EOC now is more strictly scrutinizing severance agreements. So if we don't have certain provisions in them, we are subject to attack. So one size doesn't fit all. And again, as we've talked about before, we want to make sure that, in particular, we've been harping on the ADEA, but that we're offering those appropriate days of consideration and revocation, whether we're in an individual setting, 21/7, or a group setting, 45/7. Now, I've been talking about the EOC, and it's recently, and this comes out of the Chicago division, and the Chicago division is known as being very aggressive in terms of forwarding the EOC's strategic agenda. And they recently brought suit against CVS and took issue with some provisions in CVS's severance agreement. And the issues that they, or the provisions they took issue with really went to the heart of whether or not an individual's right to file an EOC claim was in some way encumbered. So release language relative to being able to participate in an EOC investigation. Confidentiality language, which somehow can be viewed to prohibit the employee from speaking with the EOC and or other governmental agencies about issues that may be covered, Title VII, ADEA, those types of things, and non-disparagement provisions that do the same thing, all right? So now the case was dismissed. It was dismissed on a standing, because of a standing issue, so it was more of a technical issue. I don't think we've seen, and we've been discussing this as a group, I don't think we've seen the end of the EOC's attack of this. So this is something that we need to be updating our severance agreements to account for. And what I'd like to leave you with as a recommendation is the EOC, this was back in 2006, they went after Kodak for a similar violation, and this was in the Western District of New York. And language they approved there, although was still challenged here, is nothing in this agreement shall be construed to prohibit you from filing a charge with or participating in any investigation or proceeding conducted by the EOC or a comparable state or local agency. Notwithstanding the foregoing, you agree to waive your right to recover money damages in any charge, complaint, or lawsuit filed by you or anyone else on your behalf. Now that language in '06 was approved. And I don't think that because with this one division of the EOC's real hot on this issue, I don't think this language is dead. We might want to enhance this language a little bit more now to call out the fact that the employee is still free to pursue claims with the EOC, with the NLRB, with the DOL, and as a recommendation, have it as a separate paragraph, maybe bolded, all right, to demonstrate the fact that we are not seeking through a confidentiality clause or a non-disparagement clause to squelch an employee's right to pursue a claim. So I think there are some things that we can do both stylistically and from an enhancement standpoint of language that was priorly approved to help mitigate against challenges against our severance agreements. At the end of the day, understand that severance is about negotiation, okay? It's about taking control. That is, in the employment setting, we can go down one of two roads. We can litigate, which has an uncertain result and can be very expensive, or we can proactively try to take control of the situation and in the appropriate circumstances offer severance for a sum certain with the certainty that that employee will not have the ability to darken our doorstep again. You know, we as employment lawyers love principle and the fight because that's the way we make a living, right? But a good employment lawyer will balance both of those and in the appropriate circumstances advise you that pursuing severance may be the appropriate route in certain circumstances. That is so that you can take control of that situation and end it on terms that you're willing to accept.
Okay, I would say you don't be offended if you get a letter. You've offered severance, you think you've been generous. Don't be offended if you get a letter from a lawyer saying, I want more severance. That's part of business. Expect it and make a good business decision about what to do. But I've frequently seen clients who get so offended they won't respond. Well, then that's not making a business decision, but let's figure out how to get the employee out.
Right, exactly. So before, and you're having these discussions about severance and is that an option before you're planning for the actual meeting. At least it should be in a perfect world. You know, there's numerous reasons for an organization to handle terminations in an ethical and moral and rational, consistent basis. But the number one or most compelling from a business perspective is that the way an employee is treated at the time of termination has nearly 2 times as much effect as any other variable in predicting who would sue for wrongful termination. And this is really interesting because I have never had a deposition where the first reason why given by the plaintiff isn't, it was unfair. My termination was unfair. It's not, it's illegal. That comes later when they meet with a plaintiff's attorney, but it was unfair. And so can we manage that process you know, before they leave to help to make it an easier transition? I say easier because it's not easy. It's awkward. It's uncomfortable. We don't want to terminate people. And communicating that decision is difficult. So how can we help? How can we help from an HR perspective as well as for our managers who will have to be involved in those situations? Well, we can make them prepared. We can be prepared for that situation. We can have clear and effective documentation. We can work with our managers and supervisors to understand how to present or how to deliver that message. And we can make sure that we're delivering it in an empathetic but not apologetic way. You know, we want to plan for this meeting and we want to use prepared talking points. Take a moment before you go into the meeting to have talking points that can be placed into the employee's file so you know exactly what was said. And it gives you almost a type of script to rely on in that termination meeting, right? Think about the logistics. When is this going to take place? Where is it going to take place? And who's going to be present? And I think I speak for all of us when we say don't go it alone. Have someone who makes sense to be there, right? Don't pull in someone who is the employee's arch enemy, you know, to sit in on their termination meeting. But certainly having someone to witness the termination helps in being able to defend, you know, if it becomes a he said, she said as to what was said during that meeting. But also it gives a sense of finality, right? This is not a time for us to argue and debate. This is a time for us to end and move on. During the termination meeting, I think, you know, to maintain a professional demeanor is the most important. You know, staying calm, speaking respectfully to the person, not engaging in an argument or a debate about the reasons. The person's going to be angry, right? A lot of times, you don't want to be fired. But not engaging in that and trying to diffuse the situation is really important. Say what you have to say, be clear about it, and be direct, but get to the point quickly. Don't hem and haw about, you know, why we're here. You know, you should let someone know the real deal within a few minutes of the start of the meeting, right? Don't worry about breaking the ice. This is not a situation where you're going to make it more pleasurable the longer you sit there and talk. We should also be prepared for giving a reason, but maybe not all of the reasons, and that could be something. If it's very straightforward, we caught you stealing, so we're terminating you, give the reason. If it's, we have a whole host of performance issues that we haven't ever addressed with you, right? Well, so maybe we're saying among the reasons for termination are, and give some examples as to the performance situations that you may have addressed. But make sure that managers know that saying too much during this termination meeting can get them into hot water as well, right? So if you're terminating for attendance and all of a sudden the manager starts talking about, well, and you've really been a terrible employee all along and your sales numbers are, abysmal, and deviates from the reason we're here for attendance, that's going to become a problem later. Well, was it really attendance? I don't know.
Or what we sometimes see is, because it is a difficult situation, apologizing.
Mm-hmm.
You want to be empathetic, but you don't want to say, as in a case I saw recently, well, I really didn't agree, but so-and-so decided. Okay, there's a question of fact for you.
Right, exactly.
And they're right. We are relaying the message. The decision has been made. So as Nicole is saying, this is not the time to debate. This is not the time to find out if they agree with you or not. Okay, they're not going to agree with you. And I do like the suggestion of, and I know when I talk to clients about this, to the extent possible, I ask them, who is someone that's relevant in their working life, an individual that they like and trust? Because having that person in the room can really help in terms of making the medicine go down, as opposed to someone, as Nicole stated, that they really just didn't get along with.
Right. And don't terminate by text or email, right? I mean, you know who hates that? Juries. They hate that. They want to have a one-on-one connection. They want to know, we recognize your years of service or even your short time that you were with us as being important, and this is why it didn't work out. And don't get backed into specifics, right? Well, tell me every single thing I did wrong, right? I mean, don't go down that road of we're now going to lay out, your 12 years of failure. Also, be prepared for some reasonable follow-up questions from the employee, right? Will I get a reference from you? Can I file for unemployment? Are you going to tell other employees I'm fired? And have a standard answer that you can give. Or if you don't have an answer, if it's appropriate to say, I'll evaluate and get back to you. But take yourself out of not making a promise.
I think all those things go to training and planning. If you train the manager about how to respond to questions and you plan for what questions you're likely to get, then they're prepared when the employee pushes for more reasons. That's not what our conversation's about today, and you can move on. But you get backed into a corner when you're not ready, and so then you have to act off the cuff.
Right. And then be considerate of, or think about the timing that this is going to take place. Is it going to happen at first thing in the morning when everyone's coming into work and they're going to have to be escorted out with their box of stuff while everyone's coming into work? It's going to happen at the end of the day. Are you going to have security there? Think about these types of situations. Make a termination checklist so that you know the things that you want to talk about. Does this employee have property? Do they have a company car? If they do, how are they getting home that day? Right? I mean, think about these types of things, all part of the preparation. And if they have their own personal things at their desk, how are you going to get that to them? Are you going to box it up? Are they going to create a time for them to, or have a time for them to come back and get it? These, again, go back to the preparation in advance of that meeting. And then preparing your paperwork. Hopefully you have your termination notice beforehand, right, as to this is why we're terminating. Well, convert that into a termination letter. It can be simple as a follow-up to, we met on this day and last day of employment is, reason for employment, here's when you'll get your last paycheck. Just send it off to the employee as a reminder of what we've talked about. If severance is being offered, it's best to have it available, have the document available at that meeting to be able to hand it to the person so they can take it with them and review. And explain to them there may be a review period, right? Tell them what the date is. So you can say, well, I told you in that meeting, that you had 21 days to return it, and here was that date. Be mindful of state wage payment laws when that final paycheck is due to that employee, because it varies based in the state. So it may be that final day, you have to hand them their paycheck. It may be the next regular payroll. So be mindful of that as well. And then have a policy as to how you're going to deal with reference requests, right? So if you get an employment verification request, how are you going to respond? Is it name, rank, and serial number? Or are you going to give a reference? And if so, what's going to be in that reference? I mean, I think my preference would be name, rank, and serial number, but I know that tends to be a business decision for employers. Just quickly, I know we're over time, but if you'll bear with me, unemployment seems to be a situation that we deal with a lot with employers, and just want to explain that unemployment has a different standard. It's a higher standard because the point of unemployment benefits is to give people money to transition to a new job. So that's a higher standard than just a regular general termination. And with that, we're really looking at more of a just cause. Was there misconduct? And where I see employers win unemployment appeals or denial of benefits is where there's a policy that was known to the employee and clearly violated. I mean, it's really policy driven and egregious. It tends to be where employers win on that. But be consistent. If you told the employee we're eliminating your position and then you respond to unemployment, this was the worst employee ever and it was late every day, be consistent, because we now have to explain the difference between those reasons given. And know when to let it go with unemployment. I mean, it's a lot of times the cost of doing business. And it may be better to not have a record that's a recorded testimony of what the new termination reason is. You may not want that down the road. So that's something to think of as you're making those decisions. Is this something we want to fight and have a record of later?
A desperate employee cuts off from unemployment may turn to a plaintiff's attorney. You don't know,
Right.
but you have to really make, again, a strategic business decision about whether it's worth it. You might be angry, but it may be the best thing to do.
And that threshold, as Nicole said, is high. The system really is designed to pay. So the misconduct truly has to rise to a significant level.
And it doesn't mean you've made the wrong decision.
Right.
It's not about whether your decision is right or wrong.
Right. And then finally, social media has the way of now connecting former employees to employers long after the employment relationship has ended. And so, one thing you need to address in the exiting process is, does your employee have access to your company Twitter account, LinkedIn? Have they created an individual account that they use for business purposes? So they are contacting your customers on it, right? You need to know these things and who gets control of that after they leave. What happens to those accounts? And then reference requests can happen through social media. Really informally, a manager and or coworkers could be LinkedIn or Facebook friends, and suddenly they're sending, somebody sends, "Hey, too bad you got fired. I always thought you were a really great employee," and that's coming from their manager or supervisor on Facebook, and that's at odds with what the termination reason was. So be mindful of that, and that goes back to training with managers and supervisors. And posts from former employees, they're going to happen. We're going to see them, and unless they're defamatory, we have to manage them rather than they may not be legally actionable. If someone goes on and posts and says, my boss is a real jerk, he just fired me today, the boss may come into you and say, "Hey, what can we do about this guy? He's defaming me on social media." Well, it may not rise to the level of legally actionable. So we have to be mindful of that as well.
And so just to sum up, our termination best practices, again, based the decision on facts, documented facts, not emotion. Document, as we said, I think we've said that ad nauseum. Definitely have a plan for the meeting. It makes it go much smoother. As Nicole was saying, it's much better to kind of script it out just so that you have the thoughts and the reason in mind. Definitely want a witness with you. Want to have an in-person meeting. I normally like them towards the end of the business day. The meetings normally should take no really longer, depending on the situation, of course, but as a rule of thumb, 20 minutes is definitely long enough. Treat people with respect and be prepared to communicate the termination and the termination reason. That conclude. I know we didn't get to some questions here. We'll hang out and answer those questions. We want to thank everybody for attending. We hope you enjoyed this series of avoiding the common mistakes that employers make, and we look forward to seeing you all next year for the series that's to be determined. Have a good rest of the afternoon.